Hello friends, in the series on income tax cases today we will discuss a very important case which is in regard to the computation of the limitation period in case of an assessee on whom the search has not been conducted but whose papers or documents or assets have been found in the search of some other assessee for the searches made before 1st April 2021. Friends, this issue has been decided by Honorable Delhi High Court in the case of Landcraft Developers Private Limited versus Assistant Commissioner of Income Tax and another, and this case is reported in 484 ITR at page number 741 and the date of the judgment is 5th May 2025. The present case relates to the assessment year 16-17, and in the present case there was a search on A group, and in that search of A group some documents, assets were found which were related to the assessee, which is the present assessee who has filed this writ petition. The assessing officer of the searched assessee recorded a satisfaction note on 22nd June 2022, and in that satisfaction note the satisfaction was recorded that some documents and assets belong to some other assessee, which is the present assessee. So the notice under section 153C and assessment should be completed in that section. As per third proviso to section 153B clause II, second limb, the limitation period for completing the assessment under section 153C is 12 months from the end of the financial year in which the satisfaction note is recorded. Since in the present case the satisfaction was recorded on 22nd June 2022, so the financial year ends on 31st March 2023 and 12 year ends on 31st March 2024. So if we go by the limitation period according to third proviso of section 153B, so the limitation is 31st March 2024, since in the present case the assessee filed the writ petition on 26th March 2025 and on up to that date no assessment was completed. So the assessee filed the writ petition that already the time for completing the assessment is over, and since no assessment has been completed, so the notices should be quashed. When the court heard the matter, the court said that in the present case the satisfaction was recorded on 22nd June 2022, the material was handed over on that date, and in consequence to that the assessing officer of the assessee has issued the notice under section 153C on 19th December 2023. The court said that in the present case, if clause II of third proviso of section 153B is referred, then that clearly spells out the limitation period for passing the assessment order in case of other assessee, which is 12 months from the end of the financial year in which the satisfaction note is recorded. Since in the present case the satisfaction is recorded on 22nd June 2022, so the financial year ends on 31st March 2023 and the 12 months ends on 31st March 2024. Since in the present case on the date of filing the writ petition also the assessment order is not passed, so in the present case the proceedings for initiating the assessment under section 153C should be quashed. Friends, this case is very important because as far as calculating the limitation period in case of assessees on whom the searches have been made or the assessees on which the searches have not been made but some documents have been found relating to those assessees, the limitation period is there under section 153B, and that section is a little bit confusing also. So this case throws very clear light in calculating the limitation period for other assessees on whom the searches have not been made. So in the present case the court quashed the assessment proceedings and said that the period for completing the assessment is already over, so there is no use of keeping the notices under section 153C alive. So the court quashed the assessment proceedings. Friends, the assessment proceedings are changing hands in hands. From before 2002 the block period assessment was there. After that up to 31st March 2021 section 153A 153C regime was there. After 1st April 2021 the 148 regime came even for the search cases. Now from 1st September 2024 again the block assessments are there. So the importance of calculating the limitation period is always there, and it has to be seen very minutely that whether the assessment limitation period is over or not. At the end of this video, once again I am repeating the name of the case. The name of the case is Landcraft Developers Private Limited versus Assistant Commissioner of Income Tax and another, and this case is reported in 484 ITR at page number 741, and the date of the judgment is 5th May 2025. Thank you, friends.